This is Horum with Horum's Quorum. My guest today is Randy Gaw. Randy is the co-founder of the law firm Gaw Poe. I found Randy through his post on LinkedIn, and I was struck by his somewhat unconventional approach to thinking about and talking about the kinds of cases he litigates. In this episode, we talk about the path from big law to launching your own firm, the business of a boutique law firm, case selection, strategy, a lot to cover here that'll be very interesting for anyone who is looking to launch their own law firm or curious about what it's like to jump to the other side of the V. Here's Randy. Randy, thanks so much for getting on the podcast. I am really interested to have you on because of your path to building your own law firm. You started on big law and then launched your own law firm, which has grown since then. And you're doing some interesting work. And I would think it's just really, really interesting when people leave big law to go to the other side of the V. And so I'm excited to have you on here to share your story.
Thanks, Karam. It's very nice to meet you, and thanks for having me.
So let's start with your motivations for launching your firm. So you had been at two great law firms, had a significant amount of experience doing largely defense side commercial litigation work. I'm curious about what was the inflection point that said, "Hey, you know what? Any number of lawyers, I think, express curiosity in launching your own law firm, and any number do. In your case, can you recall any inflection points that said, you know what, I think this is beyond just an idea. I think this is something that I can really do, and start to take steps to implement."
Yeah, sure. I had an interesting genesis, that's for sure. Part of it was formed by the immediate experience that I had, which is in 2007 through 2008, I was involved in an 11-month trial down in San Diego. I'm normally based out of San Francisco, but I was down in San Diego and I was there for 13 months on an 11-month bench trial, which was, as you might imagine, a lot of hard work and a fantastic experience. But one thing that I observed in my role on that case, and I was one of many senior associates, was that just the way the big law firm structure worked, the senior partners, they made the decisions, and then my specific field, litigation and trial work, the senior partners are the ones who are doing all the work at trial. They're the ones who examine the witnesses, who give opening statements, closing arguments, and so on and so forth, right? They're paid the big bucks, literally. So that's what they do. And just kind of like game planning it out years into the future, there wasn't a path that I saw where I would be getting to do similar type work for a long period of time. And that's even assuming that, I was made partner, which of course the odds are pretty difficult, at a large law firm. Not only do you have to, impress the partnership, but there has to be a business case for you. And in my particular field, business litigation, it wasn't like I had any particular specialty or novel set of skills, that I could make a case for myself. So just kind of looking at it all, it was a situation where, well, I don't know if I would make partner, but even if I made partner, I don't know if I would feel fulfilled necessarily for a long period of time, because if you do litigation, you want to be in front of a jury, you want to be in front of the judge, getting to make the arguments, getting to examine witnesses and so forth. And that wasn't looking like it would happen to me, at least at the firm, that I was with at the time. So I embarked on, a period of reflection, thinking about what is it that I want? How do I go about getting what I want? And kind of serendipitously, around that period of time, so we're now in 2009, there were one or two articles written in the local legal media about attorneys like me, big law firm lawyers who had ventured off and started their own solo practices or boutique law firms. And I read those articles. I knew some of the people who were involved. Some of them were my former colleagues. So I reached out to them to kind of gather their thoughts. What's your experience been like? Do you find it rewarding and so forth? And one thing led to another, and ultimately I decided to, take the plunge, I guess, so to speak, and do my own thing.
What was it you learned from those former colleagues that helped you wrap your head around how they were approaching their firms and your approach? Like, what was it that you learned that said, okay, there's a plan here and I can act on it?
Well, I learned that one, it's doable, right? So there were all these people who were doing it, who were lawyers first and who had become entrepreneurs out of necessity. And it was a kind of an intimidating idea for me initially because I don't consider myself a business person. But to kind of see these people go through with it and to thrive, that was very reassuring. And I think, other than just sort of talking logistics and other things that kind of go involved into starting a law firm, which I was, wholly ignorant about, um, just hearing all of these people talk about the extreme satisfaction that they felt with the decision that they made. I mean, these were people who had taken ownership of their careers, um, and were doing what they wanted to do, who were getting their own clients, who were going to court, who were making money, everything that at the time I was thinking, is this even possible for me? These people who had gone ahead and done it ahead of me, they showed me it is indeed possible. And it's something you can actually be good at despite not having any prior experience in those areas.
Hmm. Did that, in terms of implementing next steps, what takeaways did you have for, okay, like here's the tangible next steps after you had those conversations? Like what came next from that?
Well, for me personally, the main next step for me after kind of talking to people and learning from them that it can be done, and deciding that this is something that I definitely wanted to pursue was to really more look into the business side of things. Like, what does it take to open a law firm? And I would say I spent like the better part of a year just looking into these things, looking at the difference between a solo practice versus a professional corporation or limited liability partnership, looking into legal software, cloud software, to run the business, modeling out things like, well, how much do I need to charge? What are my expenses? I mean, stuff that I think business folks probably would just say, oh yeah, that's, intuitive. You would do this all the time. But at least for me, as a non-business person, it wasn't necessarily intuitive. And so, I spent time just kind of like learning and reading up about what it is to open a business. What do you have to do? Why should you do X instead of doing Y? And there was actually a very, very helpful book by an author named Carolyn Elephant, who I believe that's her name, who has her own solo practice in Washington, D.C. And she wrote a book. I think it's called Solo by Choice. And it was highly recommended by multiple people, and I read it, and it was just had great advice, about what it is you need to do, what you need to think about, and why, you should go into solo practice if that is what you want to do. So, a lot of research for me, which is kind of, I would say, very consistent with sort of my approach to the practice of law in the first place.
Yeah, okay. So you took this very research intensive approach, which, as you say, I think it's very common among experienced litigators. And it's interesting because this theme of making of a business mindset as being novel was it just is keeps on coming up here. And so then how did you take that leap from how did you say, I've done enough research, now I have to act?
Well, you just kind of like give yourself a deadline for doing things, right? To force yourself into action because inertia is powerful. It's very easy to just keep sliding along and doing what you're doing, but you kind of give yourself a deadline for getting something done. And, it's very motivating. And in my particular case, I was actually coming on my 10th law school anniversary. I went to Stanford and graduated in 2002. September, I think, 2012 was September 2012, I think, was my 10-year reunion. And so it just kind of intuitively made sense. Hey, I want to have started this by the time of my 10th reunion, which I was definitely going towards too. And so that was motivating to kind of get things done by then. I actually launched on September 1, 2012. And in my particular case also, my wife, she gave birth to our first child, in January 2012. And so that actually kind of, originally I was thinking, oh, maybe I might want to launch in late 2011, but I kind of realized, that might be just a little too much on my plate, juggling so many things. So, the firm that I was with, O'Melveny and Myers, had a very generous paternity leave policy. So I took advantage of that. And, they're very good about sort of like getting people, time to, take time off to, for children and so forth. So I took advantage of that, and then kind of like just gradually sort of worked up to the point of launching in September 2012.
I'm struck with that. So I also launched my business when my first child was pretty young. And I ran this by a very successful lawyer. And, he said, really changes come all at once. And so they're really associated with each other and feed into each other. How did you find that? Because that's a hell of a lot on your plate at once. Like, how did you, experience that? Do you feel like there's a momentum effect to going through all these changes? Like, what was that like?
I'm sure psychologically that had something to do with it, right? I mean, if you're changing like one thing, why not change other things you've been meaning to do, all at once? It's sort of like if you're remodeling, just don't remodel like a room. Like if you want to have all these other changes, assuming you can afford it, like do it all at once, get it over with. For me also, it was recognition that if I waited too long after my kid was born, I would become risk averse because all right, I have an additional person, that I have to now think of. I have to think of their future, provide for them. And I might not want to take chances at that point. And so, taking the leap now before I had any kind of concrete expectations, before I had settled into something where I need to sustain a certain minimum lifestyle, that was the time to do it before I scared myself into thinking that it was too late. And, as it turned out, because I didn't have any clients to start. I certainly made no effort to poach, firm clients or anything like that. I wanted to kind of do things the right way. The first like couple of months were certainly like extremely slow, and really it took like a full year to kind of ramp up to full capacity, which gave me the free time to basically spend with my wife and my firstborn. I could leave work early, most days, and just kind of enjoy the time, enjoy watching him grow, kind of like, take advantage of a period probably that I'll never have again in my career, where there was a very low pressure environment. There were very low expectations. Mm-hmm. And, I could just sort of like I could just exist, without worrying too much.
Tell me about what that ramp up period like. So it took like a year. Like, how long did you expect it to take before when you say ramped up, by the way, what do you mean by that? So you say it took me a year to get ramped up. What does that mean?
In terms of just being fully occupied with clients such that, I had kind of like a full plate of work, most days.
So did you have an expectation heading into it? Okay, September 1st, 2012 start date. Did you have an expectation heading into it for how long it would take to get to that point?
No, because I just didn't really know, right? It's kind of, even the people who had gone ahead and done it before, they had their own unique experiences. Some of them, you already knew clients or just kind of like more natural networkers or business developers. And so I only knew for myself, I didn't know what to expect. I'd certainly not done any business development of any kind before. And in terms of preparing a business plan, one of the reasons why I felt comfortable going off and doing what I did was because I modeled that, I'd saved enough money that I can go 2 years without literally making any revenue, And so I was like, okay, I know I have enough runway to kind of really give this a try for some period of time. And if it completely fails, I can just pick myself up and try to do somewhere else, go work for another firm, go work for the government. There's, I figured that I'm a talented enough lawyer that I can probably get someone to hire me somewhere. So I had no expectations. And the first 3 to 4 months, I picked up the odd client here and there, but nothing really big. But then I think I got an arbitration matter probably 2 or 3 months in, and that, started taking up some time. And naturally, I just started picking up more and more significant type of work, which would be able to occupy me.
How did you get these matters? Is this through some efforts you were taking? It just people said, I'm thinking of Randy, I'm going to send him work. Like, how did it all happen?
Yeah, I'm thinking of Randy and I'm going to send him work. It was all referrals, and to this day, our firm, I would say like 95% of our cases are referrals. It was nice kind of like launching when I did in September 2012, in that, hey, everybody at the reunion, right, that I met, I would talk up about that I'd started my own firm. So people were naturally supportive and wanting to help. And I made sure, I just made sure to let everybody know that I had started a new firm. I got the word out. And so I was top of mind at that moment. And friends, had potential clients come to them, say, this is something that happened to me, and they sent them my way. And, the rest is history.
And then how did you skill up? I mean, had you had an arbitration before?
I mean, certainly as part of a team, right? Like, I worked on those matters for my 10 years at Big Law, but this was my first time being the sole decision maker. Like, before, my job was to execute, specific action items, or perhaps kind of help formulate strategy. Even like, as a senior associate, you're kind of helping to think of ideas and whatnot. But I'd never been the architect, so to speak. Right. I was always someone else's plan that I was following, no matter how much I contributed to the overall plans. And now it was on me. I had to think of the strategy. I had to execute it. It was a brand new kind of challenge, and it was a fun one.
How did you bridge that gap?
I mean, the only way to do it, the only way to get good at it is to have practice in it and do it repeatedly. And so I did my best in the first arbitration. I got a pretty decent result. I certainly have learned from it to become better at the second arbitration and the third arbitration and the fourth arbitration. Kind of like every case that I handle today, I'm always learning something new. Partly because I'm not in a high volume type of litigation practice, right? We try to handle matters only of a certain amount of value. And so we only work on a certain number of cases at a time. And really, all of them end up being unique learning experiences where you can kind of apply to the next such experience.
How did you manage expectations early on? So this is your first arbitration matter. How did you communicate expectations to client? The client say, hey, how many of these have you handled? And you told them, or like, how did you, or with any of the early clients, how did you communicate or manage expectations around your level of experience and what they could expect?
Sure. I mean, just be transparent, right? The people who hired me for the first arbitration, they knew that I had just started my firm, 2 or 3 months prior. And, in my particular case, I had not been the lead on this thing, but they knew about my very significant experience, for 10 years doing arbitrations and trials. In my particular example, I probably had a lot more trial experience than the average kind of like a big firm lawyer, right? I mean, just kind of like when you have an 11 month trial, then in terms of just sheer quantity, you've had more months at trial than almost anyone at a firm. But, I had at least 2 trials, I think, which is pretty rare in big law. And I had multiple arbitrations. And so I was, pretty experienced on that front. Like, I definitely knew what I was doing. It was just my first time in the driver's seat, so to speak.
And then you also mentioned a couple of different points that, you didn't have a business mindset into this. You thought of yourself as a lawyer first. is that, and that, you didn't identify then as an entrepreneur. Do you see yourself differently now, or do you still share those same views?
Um, I mean, I'm reluctantly come around to the idea that I'm an entrepreneur and I have to, I have to be entrepreneurial. For the first number of years, try to ignore it as much as possible. But that's just the reality, right? You're running a business. You have to think like a business, and you have to do things like business development and whatnot. But in my heart of hearts, I consider myself a lawyer first. And so I'm happiest working on cases, and not trying to think about the business side, so to speak, which is probably partly, why we enjoy doing contingency fee lawsuits so much. Cause, you're not sending out constant bills or worrying about the time you spend and whatever, right? You can just kind of focus on the practice of law and let the business stuff sort itself out. But, no, I mean, we are very much, now aware of the business of law and doing what we can to operate under, reasonable, sensible business principles.
What does that business mindset or entrepreneurial mindset change? So somebody who is adopting that approach, how does it impact the work you do and, structure the firm? What are the implications of taking on a business or entrepreneurial mindset?
That's a good question. I would say, I mean, like one, probably you always have to be thinking about your next source of revenue, right? Like, in the sales context, I guess you always have to be thinking about your next lead. You can't only be working on your existing lead. You have to have the pipeline, I guess, as they say. And I think that's a idea that certainly is, I don't want to say foreign, but it's not something which many lawyers are comfortable with. We're probably comfortable just working on our existing work and not having to think about, like, well, how does the next case come in? Like, where do we get that next case? Where do we get the next client? And that's sort of, at least for us, a transition, where we now are always thinking about, well, where is that next case in addition to, as we're working on the existing cases, and it's a little challenging because litigation doesn't tend to have too many repeat players, at least for us. We don't have to have too many repeat players. So we have to, like, really think strategically about where can we get future clients, and especially the clients that we want to get. What can we do to make it easier for future clients to either find us or to be comfortable with us, or to seek us out.
And what's your answer to that question today?
One, we're still trying to figure it out, right? But I would say one thing, at least that I think has been effective for others that I've seen, is getting people to understand that you're out there, that who you are, that you're out there doing the work, and that you're getting good results, right? I think there are certainly many people who are kind of like not comfortable with what might be considered self-promotion, but call it what you will. It is very effective for getting people to realize that you are out there, or to getting you on top of mind, with for the people that you do know. And I suppose it just, it really has to do with how you present yourself, right? If you're presenting yourself in an authentic manner, then it's less self-promotion, really more just kind of like keeping people abreast of what it is that you do, and why you're a good fit for people out there.
Mm-hmm. Yeah, I think you're doing a really good job of that. I think that's the key part of why I was drawn to your story and saying, hey, without being very ham-handed on it, when you talk about some of the plans you're taking in these class action cases, and some of the companies that you're suing and the counsels representing them, it's a light version of David versus Goliath. And so, like, that's a classic. That story endures for a reason. And so, those storytelling principles are effective, that, you're not gloating or going on and on about how amazing you are, but just simple narratives, I think, that do draw people and say, hey, yeah, this is a skilled lawyer taking on an interesting case. And I think that's a compelling story. That itself is a compelling story that people are drawn to.
Thank you. I mean, I'm glad that you think so. It shows that at least I'm doing something right on that field. But also, I mean, it's good practice for what it is that I'm doing. Not the marketing part, but the fact that we're in litigation, we do trials. You're telling stories about trials, and if you're unable to tell your own story effectively, how can you expect to tell someone else's story effectively, right? Like you have to be you have to be the best at telling your own story. And so, certainly whatever it is that I'm doing where I'm trying to educate people on, what it is that I've done or give people updates as to how our firm has, accomplished this or what, or even like, failed at something, right? Like I'm pretty open when about talking about setbacks that we have. It's also exercising kind of like the storytelling muscles, that we have. Like you don't get better at something unless you practice it repeatedly, and practice can kind of come in all sorts of different forms that you don't even necessarily think of as practice. Like that movie, The Karate Kid, right? Where the guy's washing a car and like not realizing that is actually kind of developing muscle memory and certain skills that translate into the various karate moves that he ends up executing later in the movie.
That's a great Karate Kid reference. I'm so glad we got into that. Every podcast episode should have a Karate Kid reference.
Great movie.
So early on, it's unless you're able to, you said, hey, I can finance my law firm for 2 years. That would be a very aggressive timetable for contingency work, let's say class action work. So then what was the transition from billable work to contingency work? Like what was the draw to that? And then how did you know that you're ready to do that in terms of the business of it, in terms of the substantive work? Like, tell me about that transition to taking on contingency work.
Sure. So we took on our first contingency case in 2014. So I basically went a year and a half or so doing only hourly work. And truth be told, I did not envision myself doing contingency work at the time I started my firm. Probably because I was still, I was entrepreneurial enough to start my own firm, but I was like, wait a minute, hold on. I don't get paid unless like I collect. That might be a bridge too far. But it kind of came about in 2014 in our first case, and we had met a client who had a great case, had been paying hourly for his current attorneys and was not getting a very effective result by them, and basically had run out of money. And I remember, a friend of mine at another firm, it was he found this client somehow, right? And so he introduced me to that person and kind of said, would you be willing to kind of join me and kind of working on contingency? And so it was like, back then it wasn't something I expressly proposed. It was, my friend who kind of proposed it out of necessity because this client couldn't afford hourly attorneys. And thinking about it, it was like, well, the risk is mitigated somewhat because, my friend's firm was also doing it, right? So it wouldn't be us just shouldering the burden. We'd be working together on this contingency case. And two, it was, a client who really couldn't kind of afford hourly rates anymore. And so it was like a binary question of, do we just take, we can't have this client otherwise, right? So it's like, is this a good case or is this not a good case? And so if this is a good case, why wouldn't we take it? Because ultimately, if you think that you can do a good job, and if the defendant is in the position to pay, one way or the other, this is an opportunity. And it kind of, that first case, kind of made me realize that there was a market for contingency cases in the business litigation standpoint, because a lot of firms wouldn't even consider it, like their business model just says, no, we don't do any contingency work at all, or we do very limited contingency fee work. And this client was considering us solely really because no other firm, that they approached was willing to do it on a contingency. So I kind of realized, well, hey, there's less competition. There's less competition, in the business litigation world if you're willing to do cases on a contingency fee basis. And if you're confident in your own skills, you will get, probably be rewarded for doing so, and rewarded well. Like we ended up getting a good result on that case, and it was, our cut of it, of the resulting settlement was definitely much higher than what our hourly rate at the time was. And that kind of like led us on to kind of like taking that on as a business model.
And so do you have a target? Like how do you identify how much contingency work you should be doing, how much hourly work you should be doing? How do you identify that next?
I would say in an ideal world, we're 50-50, up to maybe like 33 hourly, 66 contingency.
Is that based on time put in or revenue?
Time put in.
Mm-hmm.
So in an ideal world, we're 50-50, but certainly 1/3 hourly, 2/3 contingency. We have done many times. We've probably gone over 2/3 contingency. That is kind of like I said, in a ideal world. It's not there's no rule at our firm, right? Because the reality is, if there are really, really high quality contingency fee cases and they just can't, if one is coming in right after the other, we're going to take them and we'll find a way to pay for it or make it work. Right. Like we're debt free. And my partner and I have certainly invested like a lot of money into contingency fee cases, and it's a good investment. It's sort of like if you're a venture capital fund, you don't turn down like, future investments just because you've already deployed funds. It's like if this is something that hits all of your checklists and you realize that you're going to get like you have a high probability of getting a really good result. It's like you take it on, like we're in the risk business, so take risks.
How did you identify that ratio as being ideal for you?
I mean, just because it's always nice to have monthly revenue come in on an hourly basis, right? It's nice to know that you're making payroll without any problems, that you pay rent without any problems, that you can, and frankly, those are pretty low cost, relatively speaking, in running a firm. In a contingency firm, the big costs are paying for the contingency cases. The experts are, the expert witnesses cost a lot of money. Electronic discovery costs a lot of money. So really it's kind of like keeping the lights on so that you can pay for all of this stuff, especially since, under tax rules, it's contingency, case expenses aren't deductible at business expenses, right? They go on your balance sheet. And so really you're using your after tax dollars to pay for these contingency fee cases. And we, having like at least 1/3 of your cases be hourly cases, that covers your contingency fee costs, which are high. Like, currently, my partner and I were out, I don't know, like 1.2 million or something out of pocket or something on contingency fee cases. So you got to be making enough hourly and other contingency fee cases to pay for all of that.
Have you used funding in the past?
We have, regretfully.
What made it regretfully?
The high interest rates.
Sure.
It's something actually I mentioned on LinkedIn. We took funding, and the interest rate was between 20 to 30% annually. And kind of like what they, how they, pitch it to you is, well, it's non-recourse, right? So you don't have to worry about paying us back if you don't hit. Which is like, okay. So you kind of think about it and you're like, well, yeah, okay. They deserve a 20%, or 25% interest rate since they're shouldering all that risk. But then, kind of like we eventually, we did hit, and then we paid them out a lot of money because of that interest rate. And just kind of, I realized like, wait a minute, why was I so worried about it not hitting in the first? If I'm worried about the case not hitting the first place, I shouldn't be taking it on contingency in the first place, right? I mean, you're taking it on because you are very confident that you're going to get a good result, knowing, of course, sometimes things happen and you don't. But if you're confident that you're going to get a good result, then, you know, don't, don't like, what's that word they use? Don't de-risk by giving away like a very substantial part of your upside. Like if you de-risk, like, do it on a more appropriate level. And so that kind of changed those experiences kind of changed, at least my mindset about taking funding. Like funding is really only for those cases where you can't even take it on in the first place unless you have the capital provided to you by funding. So then in that case, funding makes the case possible. But if you're taking on a case, if you already have the ability to self-finance a case, then just believe in yourself, take your own risk. You save so much money, like an unbelievable amount of money because, 20 to 30% every year really adds up, obviously.
So to your point about taking on marginal cases to the extent that you can, like in the analogy of a VC, a VC might say, hey, just this option is too good to pass up. Let's go to our LPs and get some additional capital to invest. So you're saying, by way of analogy, your goal is to self-fund, a plate of cases that you identify. And then to the extent that, it sounds to me that to the extent there's an additional case that's too good to pass up, but you can't finance it on your own, that's a scenario where you think funding would be helpful.
For us. Yeah.
Yeah. And so, yeah, I get your premise about adverse selection, where, to the extent that you're leaning on somebody else for financing, like say in the context of, people, a personal residence, any number of people might, buying a personal residence is in the eyes of many financial decision. Sometimes people perceive to be purely a decision about consumption, but you can definitely make the case that the existence of mortgages, subsidized mortgages, whatever, make it easier to spring for larger prices because, hey, somebody else is throwing money at this too. But so I wonder how you think about adverse selection in the context of, case selection to begin with, because when you said earlier, hey, this company had gone to this first class action case had gone to several other firms and nobody had chosen to take on a contingency. There's two ways to interpret that. One is, hey, there's not a lot of competition for this. And so this plays into our strengths because we're lean and efficient. So we can take this on. And another interpretation is, hey, this is a dog of a case, right? Now, so it seems to me there's potentially an adverse selection even in taking on those cases to begin with. So like, what is your vetting criteria to mitigate the risk of adverse selection at that stage?
Sure. Well, I mean, you definitely take into account if someone had passed on this case who does contingency fee work, right? And at least in our case, a lot of times when cases come our way, it's been passed on by people who do hourly cases as opposed to contingency cases. So, we don't necessarily have another contingency firm's feedback, as to why they chose to take or not take a case. But, definitely, if you know that someone has if a comparable law firm has passed on this case, you ask yourself questions. And so you vet it a lot more carefully as to whether or not it makes sense for you to take on this case. And sometimes we reach a similar conclusion as the other law firm, and sometimes we don't because, we have a certain view of things. We have a certain view of our skills, and we feel like, we can get a better results perhaps than what the other firm did, or maybe the other firm is just better at making decisions than us. Ultimately, it could be both or neither.
Yeah, right. I mean, I think the thing about legal work is, of course, the reason why we're compensated. You were talking earlier about this litigation funder. They're, to be charging 20 to 30%, whatever interest rate is, because they're taking on this risk. And so too with lawyers, there's just, the risk comes from ambiguity, right? You don't know what the outcome's going to be. If you had certain around the outcome, then it would cost a lot less to finance it, right? And so, yeah, just legal work product. I think so much about understanding the business of law flows from understanding, particularly in litigation, flows from understanding that litigation is inherently unpredictable. That's how, if litigation was predictable, it would be some other thing other than the nature that it is right now. I think the essence of litigation work is that it's largely unpredictable. And of course, your goals is to do things to make it as predictable as possible, but just you can never abstract away that risk. And so, yeah, I think that makes sense that, some in the context of investing, any number of times you have one, very successful investor taking a large equity stake in a company while another one is exiting. They just have different theses on the nature of that opportunity. And they potentially can both be right, depending on their time horizon. And that also plays into your comment on being able to finance these cases. Maybe it doesn't make sense in the short term, but maybe it makes sense in the long term.
Yeah. And I mean, a lot of firms, I think, who consider maybe have passed on the cases that we've taken on. I don't know necessarily what their evaluation criteria is, or if they're a larger firm, they can't afford to take on a miss, whereas us being a smaller firm, we have fewer mouths to feed, and so we can be more aggressive in taking on a risky case, compared to them. And then frankly, sometimes there are people who, I just think are less creative than we are. Because, a lot of kind of a success in the law and litigation comes from edge cases. And sometimes there are people who are just a little too conventional thinking about the law or applying, the law to the specific facts. And they don't realize that, what, there's an interesting edge case that you can make out of this, and you have an avenue for success. So there are definitely people who are, I think, a little too rigid with their analyses, and sometimes we're the beneficiaries of that, because, we're willing to kind of like think of multiple angles in order to, pursue, a particular, path to success for our clients. I'm actually thinking of this one case that we did as a class action, and the client had gone to multiple law firms, some really big law firms, and absolutely none of them were willing to take it on contingency because their kind of very traditional analysis, just you know, didn't have like a strong I guess they didn't see it as the strongest claim or something like that. I don't know. All I know is kind of reviewing their emails afterwards, when they were, when we collected our clients' emails and, filtered them out for privilege and all that stuff, right? You kind of look at what they were saying to other law firms and what they were telling them, right? Like, oh, that's interesting. But we had approached it from a somewhat different angle, and we were ultimately successful and validated in that approach. We got class certified, we got a class action settlement, we did well financially. And so it's like, we're kind of rewarded, for our ability to identify kind of like new angles and our willingness to take them.
Can you give us more inside baseball? Like, what was the legal theory, or what did you identify that was, you're using the phrase edge case? Like, what was it that you identified that previous counsel didn't?
I mean, I don't remember the specifics exactly. And, some of it is still, a lot of it, is confidential or attorney-client privilege. But, the kind of gist of it is there was a contract, between the parties, and people just kind of like people looked at the contract and said, well, under this contract, you can do this, or you can do X, or you can't do this, right? And there are things that say you can't recover for this, so therefore you can't recover for this, and we kind of like did a more holistic approach, and it's like, well, what were they saying? What was the defendant saying contemporaneously at the time they entered this contract? What did they say after that? Is this language ambiguous? Are there certain industry norms or standards that apply here that people understand that help interpret what this means? Things like that, and so we were able to survive motions to dismiss. We were able to get class certification and, ultimately kind of present like we had a viable case. Don't know if it was, at the end of the day, we don't know we would have won or lost at trial, although we were actually pretty confident. But we found we were willing to kind of challenge conventional thinking, and in that particular example, we were rewarded.
I wonder if the ability to be more creative comes from taking on fewer cases, having more space, and just being able to think more about fewer cases. Like, can you speak to where that creativity comes from? Because I imagine you're some of these other people that firms have passed, there's any number of comparably skilled litigators, maybe with similar experiences to you, but maybe the conditions of the pressures they face at those firms are such that they have more matters or, they're stressed thin, however you want to put it. What do you attribute to why you're able to, for somebody who's comparably skilled to you as litigator, why you're able to apply this or generate this creativity?
I mean, I think you identified one of those reasons, right? We have more time, or we're able to allocate more time into thinking about these cases at the prospect stage. So that's certainly one of it. Other than that, all I can say is part of it is a kind of inherent judgment ability by lawyers, right? Some lawyers are able to think out of the box a little better than other lawyers, but in return, they have like probably worse skill sets in other areas, compared to those other lawyers. Like I would just say my partner and I, Mark, we, you know, we just happen to be pretty good about thinking creatively, and finding, doing kind of like doing the law school, the basic law school stuff. It's just like, what is the basic principle of law here? Like, how do the facts fit in this principle? And how can you, if you kind of know what the correct in the sense of like, what is the just outcome? If we know what the just outcome is, if there's a wrong that is in search of a remedy, well, then you kind of like think, well, there are, the law usually tries to find a way to remedy wrongs. And so you just kind of like, just look with that approach to seeing what other ways you can pursue this to get the remedy that the client deserves.
How often are you able to identify, or can you give examples of a time where a client thought there was a certain wrong and actually there was a much more significant wrong?
That's a good one. I would say it probably, at least in my experience, happens more in the sense that when you kind of dive into the facts of this case, you probably realize that the scope or scale of the wrong being incurred is much greater than what you had thought, as opposed to kind of like discovering a whole discrete different wrong that had taken place. I'm sure it has happened. I just can't necessarily think about
Sure.
any specific examples sitting here right now.
Mm-hmm. Can you talk some more about, earlier in when you're building up the firm, you're taking the work that you can get, and then over time you start to get more work. So I think there's two aspects of that I'm interested in: is case selection in terms of how you choose to niche. So we talked some about billable versus contingency. I'm interested also in practice areas. So like, how do you choose um, areas of law that you're saying, hey, like, let's focus on? I guess we'll start with that, and then I'll kind of work in the other jumping off points.
Sure. Areas of law. So I sometimes half jokingly um, tell people when they ask me what kind of litigation do I do, and I say, well, I do opportunistic litigation. And so if there's a case that comes across my radar, and if I think that either it's interesting or lucrative, and that we won't end up committing malpractice if we take the case, then we'll try to pitch for that particular kind of work. It's one of the benefits of being a small law firm is that you have the flexibility to do that sort of thing. You can, you just need the owners to agree, like, yeah, let's see if we can take on this kind of work, but to kind of give a more serious answer to your question, I think ultimately for us, the areas of practice that we focus on are influenced by, one, can you make a good living off of that, right? Because we want to do high margin work, not low margin work. And two, is this something that kind of is intellectually stimulating for us? Which, is not a requirement for any case, of course, but it's certainly kind of, we're more willing to kind of like go beyond our boundaries if it's a case that we think is interesting. And, also third, is this a case where we feel like we're helping people as opposed to not helping people? And that's not a requirement either. But again, it kind of makes for, an edge case for us. It's like, you know what? We want to kind of expand beyond kind of like our personal comfort zone if we feel like that we're in a position, to help people. So there are definitely cases that we've taken on in the past that we normally don't handle because one of us felt, yeah, we kind of feel sorry for these people. So let's, see if we can help them out.
Got it. And so when you're saying help people versus not help people, you just mean like people have a particularly sympathetic cause that may not be financially rewarding.
Yeah, well, yes. We don't gratuitously do like, low margin work. So, we certainly, when we're taking on a case, we want to make sure like, hey, we got to, this has to make money for us. At least it has at least the prospect of making money for us. But, we certainly recognize there are some cases that are unlikely to be particularly rewarding. Maybe we'll break even, but we still do it because we think we're in a position to help somebody, and others won't do as good a job or are unwilling to do a job, but, I don't want to make it seem like, we're these crusaders out there, right? Like, for example, we don't deal with immigration law, or civil rights or things of that sort, because that's just not that's not our background. That's not our skill set. And there are a lot of other people doing like really good work, in this field. And as much as sympathetic as we might be, like, we're just, it's too much for us to like learn like this whole area of law, or other sets of procedures potentially that we just don't know anything about. But within, the kind of like realm of work that we do, we will sometimes, go out of our comfort zone if we feel like we're in a position to help people.
How do you, for a boutique, how do you arrive? It sounds like you're going the route of opportunistic. It sounds like you're going the route of having some diversification of work. How should boutiques think about opportunistic versus strategic, niche versus diversification?
I think, one, every owner has to decide for themselves really, because it kind of goes back as to what it is they want to get out of owning a large law firm. Owning their own law firm? Is it just about like making, as much money as they reasonably can, or not? Because like the decisions are different, right? Like if you wanted to maximize your revenue, you probably are better off just kind of like really specializing in one or two, holding yourself out as an expert in one or two areas and relentlessly marketing that, and not getting distracted with other stuff, which is, by the way, perfectly valid. Like there are people who are doing a great job of that, and I admire them very much. But if your kind of like goal is to also just sort of like, keep yourself intellectually stimulated about something, the work that you do, then, your decision-making calculus is different. It's not just, oh, am I making like enough money from this? It's like, is this an area of law that I'm doing that can actually keep my creative juices flowing, for one reason or another. And I'll just use our firm as an example. We obviously do business litigation. That's bread and butter. Like most civil litigation firms do business litigation, right? Like that keeps the lights on, and it can certainly be very interesting in its own right. So we do those. We selectively take on personal injury cases. I call them catastrophic injury, that are high value. And we take them on partly because, even though the law is not particularly complex in those areas, they have like really interesting human stories, right? And so working on those cases kind of goes back to almost like, when you're in law school in the first place, like thinking, why do I want to become a lawyer? Well, this person was injured because of the wrongful conduct of another person, and I'm in a position to tell their story and to, help them get, some justice for the ills that have befallen them. So, personal injury kind of like satisfies um, that component, the interesting facts, component. And then we also do antitrust work. We have a particular expertise in this real niche area called the Robinson-Patman Act. It's the federal price discrimination. And that, kind of like, is an intellectual exercise for us because it is an area of law. It involves a lot of, economics, for example. It involves like the application of some very esoteric, laws, regarding that particular statute. And that's intellectually interesting, just kind of like dealing with like sort of these, almost policy type, arguments, in the law, and, keeps things kind of interesting for us. And, it could certainly pay well too if you know what you're doing. So it kind of like checks off all the boxes for us.
Yeah, it's really interesting to identify these different practice areas, not by, say, necessarily the economics of them or from anything structural to that. Let's say privacy. Privacy is, just there's no reason to think privacy is going in any direction and becoming more important in higher stakes. But it's interesting to talk in terms of motivations, and personal motivation and the feel that you get from these different practice areas. I think it's a very interesting lens to choose work.
Yeah, I mean, one could say it's a way we choose work. One could say it's a way that work is chosen for us, right? Like, if you're kind of just getting solicitations for the certain types of work, it's low hanging fruit, and so you're kind of like, okay, well, let's like really look into these kinds of cases, more and more, and you kind of maybe unintentionally develop an expertise in them, and it becomes self-reinforcing at a point, I suppose.
So yeah, I think that motivation sounds like an important criteria, but like heading into a year, I mean, so going back to this business entrepreneur mindset, how do you plan ahead for the year? Like what do you set as, or what are your time horizons for your goals? How do you define goals for your firm?
Yeah, we're not huge into concrete goal setting, and perhaps we should be. We're still very much learning about optimizing the business of law. But, I would say for us, we just more have abstract ideas of, okay, we're working on like these 9 cases, right? So the goal for this next year is to, how do we get good results, in those types of cases, right? Like, what do we do? How do we set up ourselves to getting the best possible result in those cases? But then beyond that, the next case, right, that I mentioned earlier, where are we getting our next cases from? Our goals are probably be more loosely abstracted to what cases do we want to get in the future? What do we do to position ourselves to try to get those cases? How do we get cases like that of higher value as opposed to lower value? Like, do we need to go out and talk to people more in order to do that? Do we need to maximize our results in these other cases and publicize that in order to achieve this outcome? Right. So we're kind of like thinking about our goals. The only kind of like quote unquote goals that we have as our firm, typically speaking, is what can we do to maximize our opportunities to get the kinds of cases that we want to work on. Because we don't set goals in terms of headcount. We don't set goals in terms of revenue or whatever. Like, that stuff works itself out. We just set goals on what kind of work we want to get and how do we get it.
If you execute on the ideas and the work that you're doing now, how will your firm be different 2 years from now?
Well, probably a little bit bigger. Like if we successfully do everything that we want to do, then naturally we'll get bigger and bigger cases to work on, which means that we have to get more and more people to work on them, and then kind of like there's a positive feedback loop in that you're getting even bigger and more interesting cases to work on, which means you have to get even more people to work on those cases and so forth. Right. And so that's why I say like the revenue headcount thing, all that stuff, like it works itself out. If you're doing what you want to be doing, you'll naturally make more money. You'll naturally have more people because you need the more people to make the more money in the first place.
And when you picture having more people to work on those cases, like what are the cases? What will be different about the cases that you're doing? Like what is there something specific that you can picture as an expectation for the mix of work you'll be doing, the stakes of the cases?
I would say so on the business litigation side, right? It would be we're kind of pretty consistently working on 8-figure type cases, like, 7-figure, 8-figure type cases. And, it would be getting to the 9-figure level, right? Consistently working on 9-figure cases, whether that's one-on-one, 1v1 or class action type cases. Like that would be like a next step for us. In the Robinson-Patman Act field, similar thing. Like we are typically working on, um, high 7-figure, low 8-figure type cases, going to mid 8-figure type cases, maybe even like, high 8-figure type cases, in this particular world, or taking on like really, really big targets, in this particular field. The people that we've sued have largely been manufacturers of, very well-known products, but, they're not necessarily the products that every household has them. And so kind of going on to the next step would be, those defendants that are making the products that every household, has. The personal injury context, right? It's like the types of cases where there is just some massive harm that was perpetuated on a large group of people and you're getting redress for that all at once, as opposed to like a 1v1, type of harm. Although, I will say in the personal injury field, I don't think we ever necessarily want to get into the mass tort field or something that involves like, multi-district litigation, MDLs like that. That's like a level of administrative complexity that I don't know if we necessarily want to deal with, since we just sort of do this stuff on the side. But, for the other two cases, that's certainly what I could kind of like set out as goals and visions, for the next 5 to 10 years.
Mm-hmm. And you've talked about the skill of, identifying interesting fact patterns, and then, the role that motivation has for you for finding work that's compelling that way. Then also the importance of storytelling. That's a recurring theme. So can you talk some more about storytelling in your trial work? How have you developed the principles of storytelling that you use? Are there recurring principles of storytelling? Is there a technique, a formula, a process that you use for arriving at effective storytelling?
Sure. I mean, when you get to trials, that's all about telling a story. There's the story that the plaintiff has to tell about how the plaintiff was wronged by the defendant. And then the defendant's story is like, no, you're not hearing the whole truth. This is the real story. Right. And so when you're at that point, it is incumbent upon you to figure out a way to present your story as cogently, as compassionately as possible, so that the jury wants to go for your client instead of the other client, right? Like trial is about motivating the jury into wanting to support your side as opposed to the other side. Because that ultimately colors how they view the law and how they view the facts. Because if they want to go for your client, when they're looking at a set of facts, they'll be interpreting it in the light that's favorable to your client, as opposed to the light that's favorable to the other side's client. So I think, effectively telling the story is how you do that at trial, is at least how we would go about doing it, is done through, one of certain ways. I mean, like one, at the very start of the case, you kind of need to like have a sense of what the story is, right? I mean, we as lawyers are trained as to like legal analysis. We're like, okay, so this is the cause of action, or this is the affirmative defense, which is all great, but you have to like kind of go beyond that and just say, what is the core narrative that is driving this story? What do I want the decision maker to be thinking about when the time comes for them to make the decision? And at least for us, when we analyze this a case, unless it's like a strictly numbers based kind of thing, which sometimes happen, like when you have claims that just involve accountings or whatever. But at the end of the day, when we are taking on a case, we have in mind there is this story to be told. This is what we want people to know. And when you kind of have figured out like the story to be told, which by the way is kind of like what makes us help us decide as to whether to take a case on contingency or not, right? Because if you're thinking, oh man, this is a terrible narrative for a jury, like the jury's not going to like our client, even if the law may be on their side, that definitely cautions you about taking this case. When you kind of have in your mind what the ultimate narrative is, then you start thinking, well, what do I need to do? What do I need to develop both on the legal and the factual side so that I can tell this story, at trial? And so kind of like when you're thinking of that story at the very inception of the case, that drives your strategic decision making, for the rest of this case, what you choose to pursue, what you choose not to pursue, why are you bringing this claim and not that claim? And so kind of like when you have like this end goal in sight, it helps you make decisions as to what to do in the first place. And then also, I do not pretend that we know everything about everything, especially storytelling. There are some very good experts out there who are much better at telling stories than we are. And because we know there are other people out there who can do it, we get their help too, right? Like jury consultants, for example, we go to trial once or twice a year on average, right? Which is like kind of a lot for a firm that does, sophisticated commercial litigation. But a jury consultant's going to trial like 20 times a year, more, and they've done it for decades. They know all the stories out there. They know everything that resonates. So at least what we typically do is as we're getting close to kind of like the jury trial phase, we send out we hire the jury consultant and say like, this is what our case is about. What do you think? What should we pursue? What resonates most with the jury? And we get great insights, like really great insights, from the people who are in the business of predicting what juries like and don't like. And that usually helps us hone the message quite effectively.
When you say what to pursue, what do you mean by that?
Sorry?
When you say you're talking to these jury consultants about what to pursue, what do you mean by what to pursue?
Oh, sorry. I didn't mean that in terms of the jury consultant. It was just more at our early stage, when we kind of like envision the narrative, you may choose to make certain claims and not make certain claims because you realize inconsistent with your narrative.
Sure. Yeah. Have you ever taken a claims first approach, a legal issue first approach over a storytelling first approach?
Certainly, because some cases don't involve particularly sophisticated themes. And so, you have a narrative, but the narrative is like, well, you have a contract and this person breached, like it's clear cut, right? Like there's a contract, service was supposed to be provided or good was supposed to be provided. They didn't do it. And it's like, this is not one where you're going to be searching long and hard for like particular narratives and themes at trial. So, certainly you kind of go for a claims first approach. And then when you're on the defense side, sometimes you do a claims first approach on the defense side, because if you feel like if this case has severe deficiencies, you can knock it out before it gets to a jury, then yeah, you absolutely analyze it from a technical perspective.
Sure.
Because your job is to make sure it never gets to the jury.
Right. Yeah, that makes sense. And would you think all things considered contract disputes are more amenable to a legal approach as opposed to, say, tort claims, which are
Yeah.
much more able to storytelling? Yeah, that makes sense.
But, tort claims sometimes, frankly, are the easiest to go from a simple claims perspective. If there's clear negligence or clear wrongdoing and someone was harmed, I mean, the claims write the narrative almost. Like you don't have to deep dig into those, right? And so, we had like recently a claim where we handled the unfortunate case of a woman who died because her fertility doctors, you know, gave her the wrong medication and like clearly breached, clearly breached standards of care in doing so. It was like an awful story. We had a great narrative for it, like our complaint and our mediation brief, especially. Like the mediation brief was like, you can frankly move someone to tears, from it. But, I don't want to pretend that that was what caused it. It was just like, look, that's just a simple legal claim issue. There's clear negligence. There's clear harm, and we, you know, any number of other lawyers probably could have gotten the exact same result as us. I'm underselling our capabilities, there, because sometimes the harm is so clear and sometimes the legal claims are so clear that, it's kind of like silly to argue that, yeah, one law firm's skill is going to get a materially, different result. Like, well, no, like once law firms are of roughly a certain level of skill, everybody should be getting, you know, that kind of result for you. And I've told prospective clients that, I'm very transparent, when they talk to us. I don't hold us out as being something that we're not. I don't hold us out as being God's greatest gift to lawyers or anything out there. I remember telling them, and there was like one case, it was like another clear case of medical malpractice. And, they gave they gave me the facts, told me what I thought. And I was like, this is what I would do, et cetera, et cetera, et cetera. And, and they said, well, why should we consider you instead of other firms? And I said, well, I said, first of all, you should know that any firm, that you're considering should acknowledge the obvious. Like you have a great chance to win, period. Because like, it's like the facts are the facts and the law is very simple in this regard. And that any halfway decent lawyer in this field should be getting you an equivalent outcome. All I can tell about us versus, what other firms you may be considering is how we would approach this case, how we would work it up, how I would personally give my personal attention to this as opposed to, delegating it off to somebody else. And you decide for yourself whether that appeals to you or doesn't appeal to you, because sometimes the facts are so compelling that, it's just a question of, whether the client works better with one approach as opposed to another approach, as opposed to any, inherent skill by a lawyer.
Yeah, and I have come appreciate in my work and the work of other, skilled professionals is that, yeah, there is plenty of room for skill and plenty of room for personal preference because, again, like much of any kind of white collar work is inherently ambiguous. And so there's many potential paths to success and different approaches that resonate with some people other than over others. So yeah, I definitely have an appreciation for that. And having factored that in for looking at comparably skilled litigators, maybe in boutiques, maybe with comparable experience that you have, what do you think does differentiate your approach over a comparably skilled peer?
I would say, just at least based on my personal experience, we we're a little unique in that, like I said, we look at the narrative first. We look at the end result. We kind of like how we look at it is what will it be like to be at trial? Is this a case that we can win at trial? Is this a case we want to take to trial? Is this a case we're comfortable taking to trial? And so I would say we kind of we have like a further time horizon in terms of evaluating the case and presenting it. So that's, one thing that differentiates us. And I would say also, another thing that differentiates is that we tend to kind of present matters to the client in terms of strategy with theming and with long-term goals in mind, as opposed to, well, what's the next step? What's the next step? What's the next step? Sometimes, when you're in engagement, like literally you're just kind of working on the next procedural step and you don't think too much further beyond that. But we tend to try to like predict, well, this is what we think will happen. And so we do this, and then that leads to this, and that leads to that. And then they're going to do this, and that leads to that, and so on and so forth. Right. And so we're just trying to map things out as much as possible and make sure that the client is kind of informed and aligned with us, every step of the way.
I talk to people who use ideas from different disciplines. So I was at a conference recently, and a keynote speaker was formerly a consultant who's very successful, then got really into chess, studied it for a couple of years, and now applies ideas from chess strategy for coaching, as an executive coach for sports teams. It's kind of this interesting application of chess. And I had Tim Yu of Bird Morel on the podcast, and so he talked about his love of professional wrestling and the ideas that he's learned from there about storytelling. So there's different disciplines that we can draw on for our work. Are there disciplines that come to mind, or principles, or that you draw on to your work?
I like that question because for whatever reason, I've been reading a fair amount of like opinion pieces and thought pieces about, well, I really like X, and that has helped me practice law for the following reasons, right? And it's always interesting to hear all this stuff. I would say, like, first, I'll give a global answer. It's like whatever works for people, whatever works, right? It's like ultimately my kind of takeaway from it is if you're passionate about something, you can always find an application of your passion to make yourself better at whatever it is you do, to be a better parent, to be a better lawyer, to be a better whatever, right? Because there is something that we always can learn from doing something, and we can apply it to other things because there are principles that are universal. Like there are ways of dealing with unfavorable outcomes or favorable outcomes, in one activity that we can apply to others, because it's like it's a process of like coming to understand, coming to accept, certain outcomes, or you're learning what your decision-making process is, that helps you realize I can apply that to other activities to help drive a better outcome. So it's kind of like a funny, I haven't read or heard the anecdote about professional wrestling, but it's just like, I'm sure it works, for this individual in a really good manner. For me, I would say there is nothing in particular that I can honestly say I reference this, or I derive my personal experiences from that to help me become a better lawyer. I would just say there's a lot of things that I just try to take from what I do in my kind of day-to-day life, or in, if I'm just doing something for fun that I realize has application to my job, right? Because just to take something like going to school and talking to other parents, about what it is that I do, right? Very mundane stuff, right? All of us do it. We say, a lot of my, the other parents at school are not lawyers, right? They have no idea what it is that we do, other than some mythicized version, of what they see on TV. How does that help me? It's my storytelling exercise. It's my storytelling muscles, right? Like I have to take a complex idea and reduce it to a level where people can understand, but also want to understand more, right? Like people want to have follow-up questions and engage and do it a way that's not condescending to other people, to like explain it to them, with respect, with sincerity, with authenticity, and get their interest, get them wanting to learn more. And it's just sort of like applying, like that kind of like level of what we do, to just kind of day-to-day interactions. I love playing poker, Texas Hold'em. That's kind of like the quintessential litigator's kind of like practice, because you're anticipating what people are doing. You're trying to model out outcomes and probabilities. You're trying to bluff. You're trying to calculate the best kind of like value proposition for yourself. It's like, well, if I take this action, what's going to happen here? And you have to come to grips with disappointment, knowing that sometimes you have your decision-making process was correct and that you get an outcome, a bad outcome, sometimes a really bad outcome, right? And then you just have to pick yourself up and realize that, what, sometimes these things happen, and all you can do is learn from the experience and figure out whether there's anything you can do better. And if you conclude that, you did most of the things correct, or you couldn't do anything better, then have the conviction to do it again, because you have to have confidence in yourself that ultimately you do this long enough, you will get the right outcome most of the time, because you're following the right process. And at the same time, if you sometimes luck into winning a hand, you play it horribly, but you get like a huge jackpot, through sheer luck, having the humility to recognize that that was because of luck, and that, what, you should be very happy that you got it, but you realize I need to improve in this and this and this and this, so that I'm not in a position again where I need blind luck to bail me out, and so, in trials, there have been times where, we've done everything that we thought we could have done and we didn't get the result we wanted, but, you just kind of have to like say, well, we got to do this again because we know this was the right process. And then there are times where, we got a result and it's like, oh, we didn't necessarily anticipate this. And so we probably need to figure out, like, how can we do a better job of anticipating this in the future? Or what can we do to kind of like exploit, this particular kind of like tendency or, predilection by the jury, like learning from it and adapting, and so that the next time we're better positioned.
Let's take somebody who is a journalist, commercial litigator, 10 years experience in big law, has quality substantial experience, someone similar situated to you at the time that you left your firm. What counsel do you have for that person for how to think about the decision to open a firm and approach?
Do you want to be the decision maker or not? If you want to be the decision maker, then make it happen. Just do the research. All of us can do the research. Talk to people, educate yourself, but then make sure you find reasons to go forward as opposed to reasons to not do it. Because ultimately, if you want to be the person who drives decisions, who architects litigation strategy from start to finish, who's the one who tells the client, I think we should do X and not Y, the one who's giving the opening statements or the closing arguments at trial, then yeah, start your own firm. Because for most people in big law, not all people, but for most people, that will accelerate your ability to become the person who makes the decisions, as opposed to having to wait your turn. But if you do not want to be the person making those calls, then don't do it, because you're putting you're not starting your own firm is not conducive to your skill set, to your mindset, and you're not putting yourself in a position to succeed. We have to have an honest conversation with ourselves. What am I good at? What do I want to do? And there are some people who will, I think, find that they are very happy not being in the driver's seat. They're very happy being the second chair. They're very happy, executing someone else's stuff. And that's great. I think there are very I think that's a great career, and there are people who are very fulfilled and do an excellent job at that. And and there are times where when I see the profits per partner metrics of like these big law firms, then I'm like, to be a service partner of some of these firms doesn't sound so bad at all, right? You just sit down and do the work and have fun. But yeah, you just need to have an honest conversation with yourself as to what you want and what you're capable of doing.
Yeah, it's great. Well, Randy, thanks for sharing your experience. It's really interesting to hear some of the running themes around, I think, particularly around motivation and how you've really reverse engineered work that you find motivating. And I think that's, I don't know a lot of people thinking about work in those terms. So I think that's a really helpful additional lens on work. And so thanks for taking the time to sit down and share your story.
Appreciate it, Karam. Very happy that I was able to, talk about some of these issues.